The Virginia Plan, 1787, read by Michael Matheson. State of the resolution submitted to the consideration of the House by the Honorable Mr. Randolph as altered, amended, and agreed to in a committee of the whole House. 1. Resolved that it is the opinion of this committee that a national government ought to be established consisting of a supreme legislature, judiciary, and executive. 2. Resolved that the national legislature ought to consist of 2 branches. 3. Resolved that the members of the first branch of the national legislature ought to be elected by the people of the several states for the term of 3 years to receive fixed stipends by which they may be compensated for the devotions of their time to public service, to be paid out of the national treasury, to be ineligible to any office established by a particular state or under the authority of the United States, except those peculiarly belonging to the function of the first branch, during the term of service, and under the national government for the space of 1 year after its expiration. 4. Resolved that the members of the second branch of the national legislature ought to be chosen by the individual legislatures to be of the age of 30 years at least, to hold their offices for a term sufficient to ensure their independency, namely 7 years, to receive fixed stipends by which they may be compensated for the devotion of their time to public service, to be paid out of the national treasury, to be ineligible to any office established by a particular state or under the authority of the United States, except those particularly belonging to the functions of the second branch, during the term of service, and under the national government for the space of 1 year after its expiration. 5. Resolved that each branch ought to possess the right of originating acts. 6. Resolved that the national legislature ought to be empowered to enjoy the legislative rights vested in Congress by the Confederation, and moreover the legislate in all cases to which the separate states are incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation, to negative all laws passed by the several states controverting, in the opinion of the national legislature, the Articles of Union, or any treaty subsisting under the authority of the Union. 7. Resolved that it is the right of suffrage in the first branch of the national legislature ought not to be according to the rule established in the Articles of Confederation, but according to some equitable ratio of representation, namely in proportion to the whole number of white and other free citizens and inhabitants of every age, sex, and condition, including those bound to servitude for a term of years, and 3/5 of all other persons not comprehended in the foregoing description, except Indians, not paying taxes in each state. 8. Resolved that the right of suffrage in the second branch of the national legislature ought to be according to the rule established for the first. 9. Resolved that a national executive be instituted to consist of a single person, to be chosen by national legislature for the term of 7 years, with the power to carry into execution the national laws, to appoint to office in cases not otherwise provided for the ineligible a second time, and to removable on impeachment and conviction of malpractice or negligence of duty, to receive a fixed stipend by which he may be compensated for the devotion of his time to public service, to be paid out of the national treasury. 10. Resolved that the national executive shall have a right to negative any legislative act, which shall not be afterwards passed unless by 2/3 parts of each branch of the national legislature. 11. Resolved that a national judiciary be established to consist of 1 supreme tribunal, the judges of which to be appointed by the second branch of the national legislature, to hold their offices during good behavior, to receive punctually at stated times a fixed compensation for their services, in which no increase or diminution shall be made so as to affect the persons actually in office at the time of such increase or diminution. 12. Resolved that the national legislature be empowered to appoint inferior tribunals. 13. Resolved that the jurisdiction of the national judiciary shall extend to cases with respect to the collection of the national revenue, impeachments of any national officers, and questions which involve the national peace and harmony. 14. Resolved that the provisions ought to be made for the administration of the states lawfully arising within limits of the United States, whether from a voluntary junction of government and territory or otherwise, with the consent of a number of voices in a national legislature less than the whole. 15. Resolved that provisions ought to be made for the continuance of Congress and their authorities until a given day after the reform of the Articles of Union shall be adopted, and for the completion of all their engagements. 16. Resolved that a Republican Constitution and its existing laws ought to be guaranteed to each state by the United States. 17. Resolved that provisions ought to be made for the amendment of the Articles of Union whensoever it shall seem necessary. 18. Resolved that the legislature, executive, and judiciary powers within the several states ought to be bound by oath to support the Articles of Union. 19. Resolved that the amendments which shall be offered to the Confederation by the Convention ought at a proper time or time after the appropriation of Congress to be submitted to an assembly or assemblies of representatives recommended by the several legislatures to be expressly chosen by the people to consider and decide thereon.